We stay in Nigeria's capital, Abuja, where the Federal High Court has issued an order blocking the Central Bank of Nigeria from releasing monthly financial allocations to the Rivers State government. Delivering the ruling on Wednesday, Justice Joyce Abdulmalik declared that Governor Siminalayi Fubara's presentation of the 2024 budget before a 4-member Rivers House of Assembly violated constitutional requirements. Justice Abdulmalik described the ongoing receipt and distribution of funds by the governor as a constitutional somersault, an aberration that cannot continue. The judge found that Governor Fubara's actions in implementing an improperly approved budget amounted to a serious violation of the 1999 Constitution, which he is sworn to uphold. As part of the ruling, the court has also barred the Central Bank of Nigeria, the Accountant General of the Federation, and financial institutions, including banks, from granting the Rivers State governor access to funds from the Consolidated Revenue and Federation accounts. To discuss this, we are joined by a lawyer and public affairs analyst, Towo Seruwaja. Mr. Seruwaja, it's nice to have you around on the news. Thank you for joining us.
You're welcome, Lekon, and it's also nice to have you here too.
Okay, so let's understand the specific constitutional provision that this justice, so to speak, is placing his premise on in terms of the violation of the presentation of the 2024 budget by Siminalayi Fubara. Let's even start from there and have an understanding.
Okay, you know, the law, the beauty about the law is that why the law is different from any other discipline or any other subject is that it's dynamic in nature. So what makes a law the law is that what may be law today may become something else tomorrow, and what may not be law today may become law tomorrow. So let's look at the scenario that played out at Rivers State. One, at that particular point in time, we have conflicting orders from the courts. We have an order from the court upholding the 4-member at that particular point in time to be the valid member of the State House of Assembly, and the others were placed under suspension or their seats were temporarily declared vacant as at when the governor presented the budget. Then 2, there is another order from the Federal High Court in Abuja that stated that, well, these are the valid members, the suspended members are the valid members of House of Assembly. So you can see the chaos created by the judiciary in this particular regard. And take it or leave it, the difference between the military government and democratically elected government is when the judiciary becomes the spirit of the law, not the spirit of an individual. So you could see that there is somebody playing the drum somewhere or people playing the drum somewhere. That is that. So as at that particular point in time, the budget presentation by virtue of the order of the court is valid. But you now see that when the Federal High Court, which some of us had reasons to raise concern, because if you look at the Constitution, it derogated powers to each of the courts. And the Federal High Court, in its own power, has stated in section 251, subsection 1, stated clearly the powers of the Federal High Court. Okay. So we don't really know to the extent if the Federal High Court has the power to meddle into the affairs or conflict between the executive and the legislative arm of government. We don't know, but you see, the law changes every time. Okay. Then the Federal High Court went further to say, well, these people are valid members of the State of Assembly, and the budget that was earlier presented should be represented into the State House of Assembly. So but that is just what it is for now. And it has really created a lot of legal concern and legal lacuna, and it also calls for legal research on what is going on in Rivers State now.
Well, so some people are actually saying that, you know, the quorum for Legislative House is 1/3. That's what the Constitution says. And we had 4 members to whom this particular budget was presented, and 1/3 of 4 is about 1. So they are saying that based on that, that's what the governor did in terms of his presentation was valid. I don't know if that holds waters.
Well, you see, lawyers, ours is to say our opinion, but the court is to say what the law is. when you say the 1/3, based on my personal opinion, is based on the valid member at that particular point in time. It didn't say 1/3 of the total state, it didn't say 1/3 of the constituencies that make up the House of Assembly. It said 1/3 of the member of the State House of Assembly. So there are two different things, there are two distinct things there. Okay. If you said, okay, 1/3 of the constituencies, several constituencies makes up the State House of Assembly. So if you said 1/3 of the constituencies that make up the Rivers State House of Assembly is another thing. So the other thing is 1/10 of the members. And at that particular point in time is who are the members of the Rivers State House of Assembly. Then let's not also forget, let's look at it carefully. Now, the question we should be asking when this judgment is made is, does the Federal High Court actually has the power to make such kind of order? That should be an issue of concern to every legal researcher or legal participant or spectator.
Okay, well, I understand your point, but then what are the legal options now available to the Rivers State government, probably to challenge the court's decision? Is there a possibility whereby they could, file an appeal to either seek a stay of execution on the order, or probably something that can help them stay on the course?
You see that God in his infinite mercy has given man the ability to seek for alternative when the people or when an institution entrusted his power, because the judges are like the representative of God here on earth. So, and what is the option given to the Rivers State government is the Court of Appeal. Let's see what the Court of Appeal is going to say on this matter, and let's see what, after the Court of Appeal, the Supreme Court. But I believe for the interest of justice, I believe they have, because if you look at it carefully, when it comes to issue of the consolidated revenue, which the Rivers State House of Assembly is after, or the Federal High Court is stopping the CBN, the Accountant General, you discover that these are previews and controls within the states, the National House of Assembly. Within the previews and control of the National House of Assembly. Okay. So what happens is that when the money hits the Rivers State House of Assembly, that is where the Rivers State House of Assembly, true, I believe, with my own opinion, with the Rivers State High Court that has enormous powers, that is not restricted to some extent, to question whether such money can leave the account by virtue of Section 80 of the Constitution, Section 120 of the Constitution. No. So that power is within them. But for issue of the consolidated money that is shared between the federal, the state, and the government is within the preview of the National House of Assembly to determine if that money should leave or not. Okay, so finally, before I let you go, of course, one would think that it would be able to generate finance for himself pending the time the issue around allocations coming to Rivers State will be resolved. But, the governor has come out to say that that is the list of his worries, that he will continue to disburse monies for contractors, to contractors for the works needed in the state. Will that be in contempt of court? Well, first of all, is to see that if the matter is appeal, it becomes, if there's an appeal and a stay of proceeding, it will not become a contempt. Then another thing again is that whether, if you look at the judgment thus far, or the report, the summary of the judgment, did not also stop the Rivers State government from money generated. Only two banks were mentioned in this outside the CBN and the Office of the Accountant General. So if the state generates funds outside those those institutions called, I think they are within the ambit of the law to work on it, pending when the Apex Court, which is the Supreme Court, we speak on this particular matter. But it's really interesting, and I think legal spectators and democratic lovers are actually looking at Rivers State as a mirror for proper definition of the federal structure we are having in Nigeria. Okay, well, according to reports, it's been said that only Lagos State and Rivers State has the financial wherewithal via their IGR to actually run their governments without federal allocation. So we'll see how long it will be able to hold forth in that line. Thank you so much, Toho Serewaja, for sharing your thoughts with us. You're welcome, Lekon.